Perfect, Danny. You can start. Thank you.
Thank you. Hello, everyone. I would like to welcome you on behalf of IAF in this webinar, which is a package of events, streaming events to promote the Master in Football Law that it's being organized by ITI with the support of IAF. And it is my pleasure to host here today three of the most important and valuable professionals in the world of football that works with transfers that I'm not gonna tell exactly which one of them worked in each and every important and complex transfer within the last years, decades, in some cases, but you can be sure that our idea is to bring to you some of the most important professionals involved in the legal engineering behind important and complex players transfers. So that's why we are receiving here Patricia Moyerson, we are receiving Carol Coles and Sebastian Ledoux. They accepted to represent or to speak on behalf the three most important stakeholders in this kind of deals, which are the former club or the selling club, the new club or the buying club or the engaging club, and the player. It doesn't mean that because Sebastian accepted to make the role or to play the role of the player defending the player's interests, he's exclusively a lawyer that works for players. He also do a lot of consultancy for clubs, investors, agents, and the same applies to Patricia, who will expose the interests of a selling club in such kind of deals. And the same applies to Carol, that gently accepted to represent, since she's English and her clients buy a lot of players from all over the world. She accepted to play the role as the representative, let's put it this way, of a buying or engaging club. So that being said, I'd like to say also thank you very much for everybody that are joining us now. We were speaking before on the backstage that we have a very mixed group with us. We have authorities here. We have authorities from FIFA. We have CAS arbitrators. We have lawyers, some of them much more experienced than me. We have also other enthusiasts of sports law or students and lawyers that are willing to join and to know a little bit more about this amazing field that brings in its core a lot of challenges, because as we will see, we have the strict sporting rules dictated by the governing bodies, but we also have a lot of decisions and a lot of influence of foreign jurisdictions that are affecting this freedom of regulation from the governing bodies. So it is a complex field. And in this international transfers specifically, you have to take care of the internal and domestic requirements, law, jurisdiction, jurisprudence, and also you have to take a look to the international perspective. And finally, just to finish my initial words, you also have to take a look not only in your contract, but also looking and protecting your interests for a possible termination or premature termination of this contract. That being said, I would like to welcome and give the floor for a while to Andrea Bossa, who I have the pleasure to have as co-academic coordinator of this Football Master of ITI. So Andrea, if you can say some words, that would be great.
Thank you very much, Daniel. Good evening to all, audience and speakers. As the academic co-director of the Master program in football organized by ET in partnership with IAF, I'd like to welcome you to this second webinar, hosting, I would say, great friends and stellar colleagues from the international law, sports law ecosystem. So hello, Patricia, Carol, Sebastian. It's a pleasure to see you all connected today. I think attendees with an interest in football law must and should feel like football fans watching a Champions League final today. I think it's a great opportunity to see all these colleagues together debating. So thank you for your time today. Just a few words to remind you that the series of webinars linked to the first edition of the Master does not end here. In fact, in April, we will continue with a spectacular webinar on women's football, focusing, let's say, on the interdependence between industrial and legal developments, with truly outstanding guests such as Ebru Koksal, Jan Kleiner from FIFA, Alejandra Gomez, FIFPro, Isabella Echevarri, former player. So this webinar, I think, will remain in everyone's memory because women's soccer is the place to be for the next 20 years in the industry. So don't miss that one too. And then we'll have another one, but I'm not going to spoil. And just a few more words to thank everyone, student candidates and professors, for the overwhelming attention for the Master. I feel truly honored to be part of this association, IAF, and I see this to the members of IAF Exco, who are welcome webinar speakers today, because from day one, I must say the association has unconditionally supported Daniel and myself in creating from scratch a master's program that has, so to speak, the ambition to present an educational offering which reflects the excellence of the academic faculty behind it and has the natural vocation to propose something non-mainstream, so to speak, within the educational landscape. So thanks again, Patricia, Carol, Sebastian, Daniel, of course, and all of IAF. And of course, also thanks to the colleagues who, although not part of IAF, are also cooperating very much and very generously for the success of this project. So enjoying the webinar. I'm done. Please do ask relevant questions. And of course, for those interested, enroll to the Master. See you soon.
Thank you, Andrea. Before jumping directly to the discussions, I would just like to remind just to have as basis of the proper perspective of the analysis for the ones that are watching us now, is that when we are speaking about transfers of players or hiring a player, if he was a free agent player, if he was free in the market, you have to keep in mind that basically you have to deal with at least the possibility to deal, depending on the negotiation, on the deal. You can have basically 4 kinds of legal instruments, which is the transfer agreement, properly said, the termination of the employment agreement with the previous club and the player, the new employment agreement, and sometimes you can also have the figure, which is a very challenging, I would say, that is the pre-contracts. So basically, you're going to see that in the discussions, we're not going to analyze separately one and another of these contracts, but they will be addressed incidentally with all the issues and topics that they will discuss. You're going to have some tips and some pragmatic information that you can apply, for instance, to the drafting of a proper instrument aiming to defend the interest of the stakeholder or the party that you are representing in this specific deal. That being said, I would like to say that we are going to receive questions and we're going to keep them to the end, so you can send to the chat, and then we're going to try to the extent is possible, to answer all of them. If not possible, we're going to select some of them. But the ones that doesn't get an answer, you can send us by email, and we will forward to the addressee of the question. So first of all, I would like to begin by Carol, and if we can speak a little bit about buyout clauses or releasing clauses of a player. If you can just explain the idea behind this, when do you use this? What are the common approach of a buying club when a player requests to insert a buyout clause in the contract? Can you enlighten us in this topic?
Yeah, sure. Thank you so much for the invite to speak. It's a pleasure to be in this Champions League final. I'm delighted. So I guess first of all, we have to consider kind of the context of the industry in which we're operating. So the FIFA's statistics on the summer transfer window last year was that there was a value of 6.75 billion euros. And this is clearly big money. I think one of the biggest markets globally is the UK, and in particular the Premier League. And one of the things we've noticed is actually there's an increasing amount of buyout clauses or release clauses that are provided in contracts. And effectively what these clauses do is provide for a potential future transfer of the player, and with that comes the mutually agreed termination of the playing contract, because you need to mutually terminate a contract in order for the player to move on. And so these are the conditions by which this is set as a possibility in the future for a specified sum. From a buying club perspective, it's quite difficult, isn't it? Because you're going to sign a player, potentially they've got, say, a 5-year contract, and you're specifying a future value of that player. So particularly when they're young, it's quite difficult to kind of work out what that trajectory might be and what is a reasonable valuation for that player. But ultimately, it's a mutually agreed term in the contract. So if both parties agree, then you tend to have a provision included for the future transfer. But I think it's not just about a buying club agreeing this sort of provision in the contract with a new player. The buying club might have almost exercised that right to acquire the player in the first place. So I kind of think about in Spain, there's cláusulas de rescisión, and these have been exercised so that potentially English clubs can acquire players. And I think about failed transfers on Ander Herrera in about 2013, because the mechanism for the buyout was fairly complex. So I think it's ultimately it's all about the detail around how do you make the mechanism work. So there's things like what for what amount clearly is the buyout, and is that a total lump sum? Is it going to be installments? What's the provision for that payment of installments? What is the approval mechanism? Is it a case of once this offer comes in, it has to be approved within a certain time frame? Who has to approve it for it to be triggered? One of the really key provisions is confidentiality, because often you have these contracts and the clauses are contained in the contract, but what the club doesn't want is for the player to be touted out effectively at this value that's specified in the contract. So they don't want the agents leaking effectively to the industry that the player can be released for a certain value. So that's one of the key provisions normally. Another key thing is about when these offers land. So what the buying club doesn't want to do is be in a position whereby they have to sell a player for a certain amount of money, even if that offer lands on the last day of the transfer window. So normally there is a certain window in which these offers can be received. Otherwise, you've lost your star player on the last day of the season. And then another provision is sometimes around solidarity and whether the amount is net or gross. Normally speaking, you've got, say, 100 million buyout clause, and solidarity would be paid on top of that. But yeah, that's kind of the brief overview of what buyout clauses are, certainly from a UK perspective.
Okay, Sebastian, I would like to hear from you how the player or representing a player, which challenges, which are the interests, which kind of clause would you like to insert, which were the level that you suggest or you advise the player to accept any amount if you want to go to a club, or it depends. How is the scale in this balance?
Well, obviously, thank you, Daniel, and same for me. My pleasure to be on the panel. I think obviously there are two answers to your question. One is on more the economic value of such a clause and where do you set it? It depends on the player's age. It can depend on the kind of market where the player could move to. It's very difficult to have a fixed rule on that, and that's often something that is being discussed by the player, the agent, and his counsel. But I would say that is a commercial discussion on the value of the release clause. I think from a legal perspective, there are two things that well, there are more than two things, but I would say two things here to keep in mind. First of all, it's to be very cautious and very precise on the details of the wording of such a clause. The more precise the clause is, the better it is. The less accurate it is, the more room you open up for discussions afterwards. If you want to enforce as a player and as a player agent, you want to enforce a release clause, you have to be absolutely sure that the conditions have been really set out very clearly, that there can be no debate. So that's very important. It can be, as Carol already mentioned, related to the timing of such clause. When can it be used? It can be related to how the amount is being considered. What is the exact amount? Is it dependent, contingent upon certain conditions? Yes or no? Is there a varying amount depending on where the player would move to, which is something that sometimes occurs. But that's very, very important. Doing that, it's also very important to keep in mind that you have the contractual assessment here, but you always have to look at national legislation. That is very important. Patricia will speak better than me on the French situation, but correct me if I'm wrong. These clauses are forbidden in France. In Belgium, you have mandatory employment law, which will set a maximum for the termination indemnity that has to be paid. So you have to take into consideration national legislation. So that's one hand, be very precise. Second advice I would give is look very carefully also to the wording, because it has a potential tax impact. And that's then mainly related to who is going to pay this release clause. Can there be any debate on the fact whether a third party other than the player would pay, being then actually the new club? Can there be any possible debate that this is a benefit in kind that should be qualified within the player's future compensation with his new club? Those are very touchy subjects, which I think you have to be aware of. We'll certainly touch base on tax elements later on. Thank you.
Patricia, before giving the word to you you can explain to us how does it work, if there is any limitation under the French law. I remember we worked in a transfer of Vitinho from Botafogo. He was the best player of Botafogo many years ago, and CSKA Moscow wanted to hire Vitinho. And according to the Brazilian law, specific law on sports, Pelé law, any contract, it's mandatory to have a compensation clause inserted in the contract, okay? This is the wording of the in favor of a club in case the player terminates a contract without just cause. And then you can put it in how many millions if the player is leaving to a foreign club. So besides all the other logistics and financial, CSKA wanted to take Vitinho no matter how from Botafogo. And the questions that crossed my mind back there, and I advised against making an act of force, which would be to pay the amount that was described, is because I could not a priori to make sure that this provision of the Brazilian law is speaking about a buyout clause or a compensation to the breach. And I think we all agree that if you're speaking about paying an amount that was established by mutual agreement by the player, you are acting according to the contract, not against the contract. On the other hand, if you are leaving the club against the will of the club, you're going to pay compensation. And then the difference is that you maybe are opening the door to the application of Article 17.3 or 17.4 of the FIFA STP. So sometimes, depending on the wording, and that's why I think Carol and Sebastian said that, you have to be really, really go to the details in the wording to make sure that you are not leaving any room to discussion if you are in front of a liquidated damage clause or a buyout clause. And I think this is a huge difference. So until today, I don't know if what the Brazilian law says it's about a buyout clause or a liquidated damage clause. So this for me is it's some part of the importance of the discussion. But if you can tell us, Patricia, if you face any situation where you have to evaluate not only this, but also what Sebastian advanced, that these clauses are considered it's prohibited by the French law. So if you're dealing with a foreign player or a player that is playing abroad, can you apply this clause? Can you use this clause?
Yes, Daniel, thank you very much. And thank you for inviting me. I'm very happy to see my dear colleagues and Andrea. And I hope the partnership with ET and IF, between ET and IF, will have a long life and beautiful webinars such as this one. Yes, in France, we have regulation, of course, football regulation, and football regulation from very long time ago prohibit buyout clause and this release clause. Why? Because under labor law, it is considered as an attempt to the freedom of the employee. And we have to look at, I fully agree with you, at national law and under French law, but also football regulation, the league regulation says that a French club cannot provide for such a clause in the contract. But as a club, if a club hire a player coming from abroad, which has such a clause in his contract, then the French club can pay the release clause. It's exactly what happened with PSG and Neymar. Okay, in this sense, I fully agree with my colleagues Carol and Sebastian. The most important is the drafting. And the drafting, why? Because when I started dealing with such contract with Paris Saint-Germain, I started a long time ago. It's 1992. I just checked before starting the webinar. And the very first important transfer I had to manage and to advise Paris Saint-Germain was the Ronaldinho one, 2001. At that time, the transfer contract and the contract was only one page. Only one page. Now we are all dealing with contracts around 10 pages. Why? not because lawyers was involved, because now, and not only because, as Carol said, it's a huge business, it's because each term is important. Each term is important. When you say that this is a release clause, in French, clause libératoire, it is, okay, how, and Sébastien says, okay, the player can do that. So you are a French club, you have a player, he has such a clause, but you have to check in his contract exactly how it works. Otherwise, if you consider that you can do that, and that the former club do not agree and says that it's not correct, or you are not paying such an amount, or it should be the player who pay that, then it's a big mess. So you have to look at the drafting on the contract, on the other contract, and on your side, you have to be very careful on national law, and specifically national tax law too. Because if you get a player and you pay, and I just in the newspaper right now, today, I don't know, because I'm not anymore Paris Saint-Germain lawyer, but there is an investigation under this transfer from Neymar to Paris Saint-Germain. Why? Because tax and social contribution, they think that Paris Saint-Germain should have paid tax because it's a benefit, because they consider that Paris Saint-Germain paid the amount on behalf of the player. So it is, in their view, the national authority, they think that the big amount they paid to the Barcelona was a bonus or a salary which should have been paid to the player in order to allow him to pay this amount to his former club. So you know that it's very complicated. And then, yes, drafting is important, and checking national law, your national law, and the national law of the other club.
Thank you, Patricia. We're not gonna go further on this, but I think we can, at least I think we agree that it also applied to buyout clauses, the same limits and the same dangers that we see in compensation or liquidated clauses, right? Which means if it is really excessive, you have the risk that FIFA or the CAS or a national court can annul it, can consider null and void, or at least to adequate and to reduce the clause. So this is always risky, especially in South America, where a younger player with 16 years old, you can establish a very high amount of selling clause. And one only last remark about this is also, I don't think it's proper to analyze if the clause is null and void because it's excessive, looking at the moment where the contract was signed, especially if he is a younger player. Because if I put 20 or 200 million euros for, I don't know, Vinicius Junior, maybe it's not unreasonable when he was transferred already, but it wasn't reasonable when he signed. So I think the scrutiny of the validity and if it's balanced or not must be done in the moment of the termination with the former club and not in the beginning, because the clauses shows if it's proper or not according to the development of a player. Just to provoke that we can think a little bit more for 2 more hours of discussion in another webinar. So jumping to another issue, and I would like to begin with Sebastian. Bonuses clausing, okay? Basically, I'll come back to this with Carol and Patricia about bonuses in favor of the former club or the selling club when the player is transferred to a new club. But I would like to hear from you if when, for instance, Chelsea agrees to pay something to Bordeaux because they bought a player from Bordeaux, which kind of impact could this arrangement, depending, like for instance, If Chelsea use the player for more than 20 matches in the first year, they will pay Bordeaux a certain amount. And that maybe could be detrimental in terms that Chelsea would not field. This is hypothetical, of course, okay? But so can you see that such kind of clauses can somehow impact the player's interests?
Yes, of course. Well, when you speak about bonuses in transfer agreement, the player is a third party to a transfer agreement, and it is as such, it's an understanding between two clubs. And so, in principle, there is no direct incidence for the player. I'm saying in principle. Now, there is one in the sense that it's an economic operation, that we always tell players that when you assess a transfer operation, it is like a pie, and the money always comes from the same side. It comes from Carroll's side, the buying club, and it is being spent on the transfer fee, the player's salary, whether it's fixed or variable. It's potentially a signing fee. It's the intermediary fees, and obviously, yeah, the transfer fee is part of that. So the player has an interest in knowing that, and transparency is very important. So that's maybe an answer to the economic aspect of your question. From I would say a legal perspective, the main impact for a player, and pardon me, Daniel, I don't see that much as a bonus, but more in transfer agreements, and especially in loan agreements, temporary agreements between clubs, where a player is being on loan for 1 year. There is an option in that agreement whereby the club which the player is on loan with can lift the option. There it is very important for the player to be aware and potentially, I'm not saying in control, but at least on the purchasing side, to be on the side of that club, to be very aware and accurate in the definition of those conditions. So going from a loan agreement to a permanent one is a very important one. And I will use one example which has been broadly used and mentioned in the press, and you will remember it's when French star player Antoine Griezmann was on loan from Barcelona to Atletico Madrid. And there was a triggering event in the clause to make it a permanent transfer, which was related to him playing, I don't recall whether it was exactly a number of games or a number of minutes. Well, obviously, that has a huge impact on the player, because if you are not aware of that, if you were not at the table and you try to influence that, obviously, in the end, you still have to give your approval on the personal terms and the employment agreement, but it has an impact. So I don't know if that answers your question, but that's my first rough feedback on this one. Thank you.
Yeah, sure. Patricia, your thoughts about, and if you can give us some examples of the usual clauses that a selling club would like to have on its behalf when it transfers a player and agree on bonuses, like 45 minutes or a certain number of matches, or beginning with in number of matches in the A team, in the 11th players. I don't know which kind of examples can you give us of the more often bonuses clauses that you've drafted?
I think that what is extraordinary in this matter, and as lawyer, I'm very happy because there are so many creative ideas. Our clients, they are very creative. Agents are very creative. Lawyers are creative. So each year we discover a new kind of bonus. Could be linked to appearance, could be linked to the result or the outcome of the team. For sure, the selling club, what they want is to get the maximum chance to get the maximum money. And as my experience is that both president, let's say, or general manager, they agree very quickly. Now I can see that they agree by WhatsApp, or 2 or 3 WhatsApp. Okay, the deal is done. We agree. And then lawyer on in-house lawyer or not in-house lawyer, we have to write clauses based on just one WhatsApp. And then we have to take care not only on the drafting, as Sebastian said, but also take care of each word. I've seen so many French clubs who work without lawyers because they want to go quick, fast. The president, everybody's in a hurry. And then just think, okay, if he plays 40 games, okay, which kind of games? Which competition? Amicable are in or not? During how many years? What happens if the player extends his contract? Do we consider the 40 games with the extension of the contract only in one season? What happens if the player goes on loan? So that's why we have to listen. First, I think that our job is to listen carefully, then ask questions. Then it's important to know and to have experience, of course, and to have a lot of imagination. What happened if? What happened if? And then we have to draft this in case such occurrence happens, then the bonus will be this one. And then after we have, but I think we will discuss about that to consider if there is or not solidarity contribution or this bonus. So just to say that it's a long process with could be a short exchange between the 2 presidents, and for lawyers, it's longer and longer to draft and to negotiate with the other lawyers. To negotiate, each word has to be negotiated. The truth is, my experience, I never intervene in the amount or percentage. This is not my job. I never had to discuss with my dear colleagues about an amount 10 or 100 or no. I always negotiate on words, only words.
Daniel, can I maybe add one example to that, because it's very important what Patricia said. I'll give you an example just from our practice. With each club where we negotiate on behalf of a player, whether it's a modality for a contract extension or for additional financial compensation, such as a bonus, which is related to game appearances, one of the discussions we have is, do you consider all games, or do you consider only games for which the player was available? Whether it is because he's fit, he's not injured, or he's not suspended. And you have clubs who say, no, we never do that. Then it depends on the bargaining power that you have as a player. But you can spend a whole lot of time just on discussing one word. Just wanted to add you that. Thank you.
No, and I agree, and you are complimenting yourselves, because actually, Patricia, what you're saying is that when the president of the clubs, they agree, Patricia, the one that is selling is just looking at the amount that is coming with the transfer fee, usually. And the one that is buying doesn't mind to promise something for the future that is not very tangible. And he thinks, okay, if the player is too good, then I pay more in the future. But now for financial fair play, I'm fine. And then they give it to us to rediscuss everything. So, Carol, I'd like to hear from you first. First, easy one and then a tricky one, okay? The first one is, which kind of clauses usually, when you're representing a buying club, you think are reasonable, which are over the limit? I think it's difficult to accept. And finally, and you don't have to give any names, or just a witness from you. Have you seen any situation where a club simply did not feel that the player, because the the target to pay the bonuses would be reached?
Okay. So I would say that the bonus clauses are obviously they're common in transfer agreements. I would say, depending on the balance of power between the buying club and selling club, and the nature of the player, whether it's a young player at his peak, or a player at, the tail end of the career, it depends on the element of conditionality in the payments due. So you're more likely to get more conditional payments where a player is at the start of his career, because there's likely to be a lower upfront guaranteed payment, and then the conditional payments, which will be paid on the basis of effectively him performing at the level that you would hope that he would perform at. So regularly playing, achieving success on a personal level or a club level. And equally, it may be the case with old players as well, that payments would be conditional on the value that they're bringing to the new club. So yeah, I would agree with everything Sebastian and Patricia have said. The devil is in the detail. You can have lots of negotiations over what appear to be quite innocuous clauses. So appearance is the key one normally. What is the appearance? Is it of the game time? So sometimes you'll have a percentage of minutes. Well, percentage of minutes played now is when you're thinking of game time, matches are an awful lot longer now. So whereas we used to have things like, if a player enters the field of play prior to the 70th minute, well, maybe that's not applicable now when you're playing games going up to 100 minutes sometimes rather than 90 minutes. What happens with extra time? So it's the intricacies of all of that. And the other detail around, I guess, appearances, well, it's the amount of time. It's whether they're a starting or a sub. It's also the competitions, as the guys have said before. So there's been a CAS case about a reference to games played. And actually, because there hadn't been a specification of the competition that referred to, under FIFA's regulations, reserve team games would qualify as games. They're part of the official calendar, and so perhaps something that the parties had just hadn't addressed their minds to then became quite a pivotal provision in the contract, and vast sums of money are due. So
if I may say, a lot about the South American market.
Mm.
We have competition from the state in my state now, so it's a very small competition. There's a huge difference between considering also this or only the Brazilian Championship or the Brazilian Cup.
Yeah, exactly. And say in England, it's often the case that perhaps the League Cup competition is one that maybe the younger players might play in, whereas say FA Cup and Europa and Champions League competitions might be more of your A team, and so therefore there's a kind of a value attributed to the types of games as well. In terms of your second question, and whether I've seen kind of a provision in a transfer agreement that's then impacted on a player, I mean, the one that springs to mind isn't totally on point because it's not the transfer agreement, but the principle is the same. So Jonas Gutierrez obviously played for Argentina, and Newcastle had a provision in his contract that if he played 80 games, that would trigger the offer of a new contract. He was diagnosed with cancer and effectively was sort of excluded from the team. And he was only reintroduced into the team at 78 games. When he could only play 78 games, so therefore would not trigger that provision. So yeah, you can see how these sorts of clauses could really prejudice the players down the line. You sign the player, the relationship's great, and then down the line, who knows what's going to happen and how those clauses might be interpreted and used against the players potentially.
Can you refresh us and tell us what was the outcome of the dispute?
So yeah, it was a disability discrimination claim, and Newcastle was found to have been sort of guilty of disability discrimination. So effectively, they hadn't played player for those games due to his cancer diagnosis. and therefore, significant sums of compensation were due, and it purely came down to, this provision about the trigger for the new contract.
Yeah. Okay.
Daniel?
Yes.
Daniel?
Please. Yeah.
Yeah, maybe I can give you a nice one that
Sure.
showed that popped up recently. It's you have whether it's transfer agreements or employment agreements. For instance, you can have triggering criteria related to Champions League participation. What if someday there's a breakaway league? You sign an 8-year contract and you have a bonus for a Champions League, but your team is going to play in the breakaway league. So now you're seeing that there's wording being phrased or formulated on alternative leagues. That's something you would not think of, but actually some lawyers do. That's the nice part of I would say, of our job as lawyers.
I think
If I may,
yeah, sure. Sure.
just to
Of course.
add something to Carol, it is important to look at national law. In French civil law, if you put a condition in a contract saying that you will have a bonus if you play, in our law, what we call a potestative condition, it is a condition which makes the execution of the agreement depending upon an event than one of the contracting party has the power to bring about or to prevent. This clause is null and void. And I have seen a contract between a French club and the English club. And under the French law, the condition was for sure null and void because the condition depended only on the buying club. He could make the player play or not. He could make the decision. But the contract was submitted to the English law, and under the English law, such a clause is not annul the contract. So when drafting a contract as lawyer, sometimes it's very important just to try to get your national law to submit the contract to your national law better than the other. For sure now, what I can say, my experience is in Europe, a lot of contracts are submitted to Swiss law. Why? Because we all know that at the end of the day, the Swiss law will apply and CAS would apply the Swiss law. But sometimes it's very interesting and you can get a lot of advantage by submitting the contract to your national law.
Thank you, Patricia. I wonder, I think we can say that some of this, depending on the drafting and depending on the content of these clauses concerning the bonuses on transfer agreements and also on the employment agreements, can be a risk that there is a violation of Article 18 bis of the RSTP that provides about the prohibition of third-party intervenience, okay? And I wonder, it's more clear by the CAS jurisprudence also and FIFA decisions that it applies to the bonuses, but especially if we speak about sell-on clauses, there are clear limits that shall be respected concerning the non-violation or respecting the content of Article 18 bis of the FIFA RSTP, which we all know that basically prevents any party to have an influence on the transfer politics or all the power that the club that has the registration of a player should have, all the freedom to the extent as of an employer, limited to the player's rights, of course, but is not allowed to a former club to somehow intervene. And we know that many sell-on clauses go to the limit or even are flirting with a violation of Article 18 bis. But my question is, and beginning from you, Patricia, which kind of clauses as a selling club specifically would your clients are willing to have in the contracts? Which are the common formulas that you use when you are selling a player to England or to Spain? Which kind of clauses your clubs are usually trying to impose or to agree?
It's difficult to say because each club is different and each club has its own politic. But I would say that talking about the sell-on clause, the sell-on clause is the selling club consider that they want to participate and to get an incentive if the player perform, or if the player is under a new transfer, if the buying club sell the player another time. And of course, the discussion between the two clubs is, what is the incentive? Should it be 10%, 15% of it's an earn-out clause, okay? But if you talk about some big club, they could have the idea putting the player in a small club for a small amount, small fee, small compensation, and decide that if the buying club is selling in the future this young player, the former club will get 60-50%. Of course, this for me, it's much more than an influence, because you could see that the buying club will and the selling club, they will discuss, and if there is an offer, they would probably decide together. So the selling clause is the simplest way to have this selling clause is to say, I will get as a selling club a percentage on the future transfer. Now, two difficult things in how to draft this, a percentage on what, how we have to consider in case of a future transfer, but as we've seen, is what is a transfer? What happened if the player had a release clause and use this release clause? Is it a transfer? We have case law on this with French club, actually. And what happened if, and this is one case I had between, I work for a French club who sold a player to another French club. And the idea is, well, okay, I would like to have a percentage on the future transfer, but I would like also to have a percentage in case you succeed to extend the contract with the player. Because it shows that if you, as a buying club, you extend, it means that the player is very good. And I sold you a very good player because you extend it. So this is the new way to look at it and to consider that the player is an asset. And at the end, this asset, the benefit of this asset should be shared between the two clubs. And I think this is only the beginning. We will probably see in the future new aspects and new idea about being interesting in the future of the player.
Thank you, Patricia. Thank you. Carol, your thoughts about that, since you suggested the topic. So how do you see that? Which are the most, strange requests on this field? Which are the clauses that you think can be considered? And we have some decisions of FIFA that did not touch the validity of these agreements, but applied fines by the violation of 18 bis. So what are the problematic behind of this? What are the limits to settle a good clause, or what can you say?
Yeah, so it is ever evolving, and as everyone said before, it's interesting to see kind of how inventive the lawyers often can be in terms of, you know, the what if scenarios. So you factor in every possible thing that might happen. So when we're talking about sell-ons, we're not just talking about a transfer fee being payable. So there are often provisions and sell-on clauses, as Patricia has said. You know, you can start off years ago, you used to just have maybe one clause. Now you can have pages just on the sell-on. So yeah, what happens in the event that the player terminates and compensation is due? Is that then, you know, do you agree that that's effectively a transfer fee because you were deprived of the transfer fee, and that's then paid as a sell-on? What if there's a player swap? So, or as part of the parcel of the deal, there's a player swap element. How do you value that? And what's the mechanism for that? So you can have lots of provisions around where a dispute might go to specifically on that point. What about a loan? So can you deduct, say, payment of salary that you you know, kind of selling club have, the club that's due the sell-on fee? Can deductions be made for loan provisions, so salary that has been made? I mean, I think the key is when there's sort of provisions around what might happen in the event of a sale to a particular territory. I think we've seen some cases around that. So I think there's the Manchester City and Real Madrid case, which had provided for a lower transfer fee, I think 15% sell-on fee, 15% sell-on fee ordinarily. But in the event that there was a transfer to a Greater Manchester club, it was going to be 40%. Now, that was deemed to be an infraction of 18 bits.
Rivalry clause, yeah.
Yeah, and similar to Arsenal, there was cases around Arsenal whereby there were provisions for a fixed a fixed sell-on fee in the event that it was a sale somewhere else in the world, but an increased levy almost penalty, you know, in the event that it was a resale to a UK club, and again that was deemed to be infraction of Article 18 bis.
Sebastian, about this, you are advising a player that's signing with Manchester City, and you are aware because your player has to sign the transfer agreement, agreeing like intervening party, and you know that if Chelsea wants to hire him, it's going to cost twice or 3 times, and that can prevent a future transfer. How can you, in addition to this situation, which can be detrimental to the player in the future, but you were aware of this? So first of all,
yes, but you're touching a bit the limits of where you can go also as a player, because in the end, you are under contract. In order not to be under contract with your current club and to move on to a new one, there needs to be an understanding between the former and the new one, and there's only so much you can do. So as a player, even you are the subject of the transaction, you are a third party to that economical transaction between buying and selling club. What we are, so I don't know if that answers your question, but the limits you have there are real. What is something we have seen or we are applying increasingly over the years is a sell-on percentage at the player's benefit. So we've seen this at the benefit of agents, and it's still being applied, despite being in violation of FIFA regulations. There has been some tolerance on that.
Just to explain better for some of us that are not very familiar to this, the player as someone that is entitled to have part of its own economic rights.
Yes, the player is not being considered as being a third party.
Yeah,
it's not infringing FIFA regulations, and so as part of his compensation package, the player can negotiate also a part of the amount that his current club is going to receive when he's transferred to a new club. Needless to say, that can be a very important amount, and it can be a substantial part of the negotiations. Obviously, when your compensation as a player depends on an understanding between two other entities, you first of all need transparency. You need to know what is being on paper. And that is now, I would say, almost standard, that the player signs, or at least is a witness of the transfer agreement, and he has at least a copy of it, so that transparency requirement is being fulfilled. But then on your personal negotiation within your employment agreement with your club, whereby you're going to say, if further down the road I'm being sold to another club, I am going to have an entitlement on this transfer. Again, it's the same remarks as what Patricia and Carol said. What is a transfer? Is it only a permanent transfer? What if I'm going on loan? Do I get an entitlement on the loan fee? What is the calculation base of the transfer? Is it the aggregate transfer amount, or is it only the increase? Sometimes you have clubs that are not really cautious and that say, well, there is an entitlement on the transfer amount, while they actually have already paid a transfer fee to acquire him, so it should only be on the increase. Sometimes it's not mentioned. It can be very important. Is it on the fixed? Is it on the variable, the bonuses on a transfer agreement? What about a sell-on a sell-on? So which means you are negotiating as a player a share of a future transfer fee, but that future transfer says, the club then will say, yeah, but then again, if there is a subsequent transfer, so a second transfer, I will hold also an interest. Do you then apply your stake on the first transfer on that subsequent share? Those are things that, well, you negotiate. Again, if you're not being accurate on that, you could be bounced. So it's quite important. For instance, you also want, to the extent possible, to protect you from any artificial waiver of sell-on fees. It could be, because of an understanding between clubs that they say, listen, we are going to drop the sell-on entitlement that you have on the transfer of that player, but on the transfer of another player, we will just apply it. Well, if you then, as a player, if you have a share in that sell-on, you are being, vulgarly said, you're being screwed. And then again, the creativity is really nice. I'll give you one final example on that. There was, and it's actually more the team that was duped than the player. There was a quite well publicized case in Belgium where a team bought a player from a smaller team in Belgium, said, we buy him for 2 million. If the player is being sold for an amount above 2 million, you are going to get an entitlement of 40%. As Patricia said, sometimes for smaller teams, the percentage then on the sell-on fee is higher. Now, what did the buying team do when they sold effectively the player to a Middle East team? They sold him for a little more than 2 million. It could not be too obvious. So they put in a couple of 100,000 more. But actually, there was a quite bigger amount of a few millions that was not being labeled as a transfer fee. But all of a sudden, around the boarding of that selling team, then the buying team that became the selling team, you saw advertisement for visit this country in the Middle East. And there was a training camp being organized. And so the club tried to cover up an amount it received from the Middle East club by saying, no, this is not a transfer fee. This is a commercial agreement. And we have received this money because there is boarding alongside the pitch, which promotes tourism in our region. And the club is coming on training camp. So you see, again, there, creativity can go very far. And you have to try to protect yourself to the maximum possible. But sometimes creativity goes beyond.
Very expensive friendly matches also can apply. Listen, can we jump to beginning from you, Sebastian? And I'm afraid I have to say that we have to be more. It's amazing. For me, you know, I like to talk to all of you as we do all the time, but we have to run a little bit. So we have to be more direct to the point. But now I'm going to put two topics together, Sebastian. Which kind of provisions or clauses are important when you're speaking about the financial compensation, salaries, bonuses of a player, also touching a little bit quickly about tax issues in an employment contract?
Yes. Well, okay, I think they have been touched upon already within the discussion on bonuses, on criteria, on games, on appearance time, all these things that's important. Maybe a few ones I could add. We highlight the importance of the player being registered with the A team. That is, you know, depending on the power of your player, whether you can enforce that or not, but it has a financial impact. We try to carve out, obviously, the revenue that a player can have on a personal level for his boots and other personal sponsors. So that's what we call the carve out of image rights. The rest, I think, on financial compensation has been touched upon. Taxation, obviously, is a very important one. And I would say to all students that are following other fellow colleagues, they obviously are aware of this, but we all have seen the increased importance of tax matters in international football. I think 20 years ago, tax administration was actually not aware of how football operations were being handled. I'm looking at Carol. In the UK, they were a bit advanced, or a lot, but on the continent and in many countries, it was not being looked at the same. I would say,
I'm sorry, just to provoke you, if you are representing a player,
yeah,
you are happy with only inserting the wording that your client will receive a net amount, that would prevent him to have troubles with the fiscal authority?
I will try as much as possible. I was actually going to say on taxes, when you represent a player, three things to keep in mind, mainly. One is obviously the entire gross net negotiation. Very often contracts are gross, but if you are able to include a guarantee on net character of payments, that is very important. I look at France, I look at Italy, who have specific regimes with the impatriation, with the Decreto Crescita in Italy. It's very important, and Andrea is there. He knows we've worked very often on similar cases. These are clauses, where you can spend hours negotiating. That is very important for a player. Second element with respect to tax, very important, is tax residency. That is then related to when are you going to receive payments? What is the nature of the payments that you receive? Is there a double taxation treaty in place between two countries where you move? To give you an example, family residency is a very important one. We once had a player, we were consulted by a player who was playing outside of Europe, and he kept his family living in Spain. Now, you all know that Spain has becoming more tax aggressive, so to speak, over the last 10, 15 years. And there was no double taxation treaty with the country he was going to. In the end, the revenue, which was a very generous net revenue he was earning in that non-European country, turned out to be taxable in Spain, because the player just left his family in Spain, and the Spanish tax administration said, we consider that the center of your interest, family interest, is still being in this country. So it can have a huge impact. Final element, third element with respect to taxes, is agent payments. Obviously, that's a very important one. Then we will touch upon single player agent representation, dual representation, where an agent represents both the club and the players. You have a discussion on player services, club services. if that is a simulation, if an agent agrees with the team that he's being paid a certain amount, and it turns out that he's actually not delivering any services or very little services for the club, but that he's mainly the player's agent because he's on the picture with him, because he's on his Transfermarkt page, because he's on his own website, well, that is a benefit in kind, as was mentioned earlier. And it means that the value of the commission that is being paid to that agent will be added to the taxable personal income base of the player. Now, if the agency fee is only 50,000 euro, well, okay, you will pay marginal tax on that amount, and that is okay. If you are not even aware as a player of the amount that is being paid because it's a private agreement between the club and the agent, and it's being labeled as club services, but effectively it's player services, and it turns out that that amount is 1 or 2 million, well, you can figure out how much the tax administration is going to claim. I think those 3 points are key, absolutely key, when you advise a player in contract matters. Thanks.
Thank you, Sebastian. Patricia, any thoughts specifically about France or anything that you would like to add or to underline?
I think that the selling club, what is important, because now what we can see is the transfer fee are payable by a lot of installments. And what the selling club wants is to be able to assign these receivables to banks. So banks are involved, deeply involved. And a selling club cannot work without this bank and being sure that he will be able to make factoring and get. So the bank are involved, and now what I can see is the bank are looking at the transfer contract. Of course, they want to have guarantee. And this is the second aspect, is how could you have, as a selling club, get guarantees? Could you get guarantees? So here, to be inventive is important too. You can try to have guarantee on the TV rights, on some other assets from the club, because you can have a fantastic transfer contract, but at the end, as we can see, a lot of clubs, even in UK, are collapsing. In France, each year we have one big club going to bankruptcy. So this is, for me, the main now new aspect. And also be very careful, we didn't talk a lot about that, is when you release a player. And the timing is very important in transfer. Mostly, sometimes the transfer, both the president agree long time before the window open. So we talk about pre-contract, promise of contract, etc. Or transfer contract are dealt at the very end of August or January. And the timing is very important. So as a selling club, you have to be careful to the timing. When do you sign the release, the termination of the contract player? When do you sign the transfer? When do you ask for deal with the ITC, the delivery of ITC? And sometimes on the timing, we have to be very, very careful. And if you think, and then when we talk about Salah case, for instance, this is amazing case. Who could believe that the player would have such an accident? So it shows that the timing is very important. Sometimes the president and the clubs, they don't see any issue, but as lawyer, we know that the timing, who is obliged to do what thing to be sure that you release. And I had a case of a French club who release and sign the termination of the player without saying that the termination was conditioned upon the player going to this club. So they signed the termination of the player because they thought that the deal was done. And at the end, the player didn't find an agreement with the new club. So the player said, no, I won't go to this club. I don't like this club. And the player was free. Yes, he was free because the club, the French club, signed the termination. Okay, we agree. We agree on amicable termination on that date without saying that it was conditional to the player going to this club, not another club. So each year we learn a little bit more. Each year we learn and we teach our client to be more and more careful, more and more cautious.
Patricia, I think if I'm not mistaken, there was a very old case concerning Neymar, not Neymar, and Lyon and Corinthians that was kind of this. It fits your example. It was exactly like this. Parties fought, parties deemed that they had a deal, but they didn't have the paper, and all of a sudden they didn't have a deal, and the player was free. So it was a huge headache, a very expensive one. So since we're running out of time and you mentioned pre-contracts, I wonder, Carol, we know that it is already difficult enough to deal with transfer contracts according to FIFA rules, especially the RSTP. But we can make it worse by dealing with pre-contracts, which we know that you can apply by analogy from what we saw from the jurisprudence, many provisions of the RSTP, many ones, but not all of them, not automatically. So which aspects would you pick to say that there's a specific idiosyncrasy in this aspect concerning a pre-contract? And if I may ask, what is a pre-contract? If you can explain to all of our viewers, because not everybody are working already for so long like you in this field.
Well, sometimes the definition of a pre-contract is the very crux of a case, because you can label something a pre-contract and actually it might not be. But generally speaking, it's setting out the conditions on which a contract, so that could be an employment contract and or a transfer, will come into effect. So it's sometimes the case, it had been really prevalent, where you could take options over sort of young, promising players, where you'd have sort of partnership agreements particularly between UK clubs and foreign clubs, and you'd have options over these players for the future possible transfer of these players, but you could secure the players for a particular transfer fee.
Sorry. Then you're speaking about the twins of Manchester and Fluminense, Wellington, but this is a pre-contract with the agreement of the former club.
Yeah.
And we have the other kind, which is against the will or the wish of the club that the players register, right?
Well, so I suppose on the whole, we tend to deal with the pre-contracts whereby you've got the agreement with the club that is going to transfer in the future, and you back to back that with the agreement with the player. So you know what has to be satisfied, and then that agreement will happen in the future. I think one of the key provisions there is to ensure that it is enforceable. So from an English law perspective, if we've not got concrete terms around what is going to happen, we would refer to it as an agreement to agree, which is effectively not a binding contract. You're agreeing that in the future you will sit down and agree terms. So what often happens in pre-contracts is we'll have the full contract that is going to be entered into appended to the pre-contract, so everyone knows exactly what the terms are that are going to be entered into. It's just what might trigger that in the future, and so I guess there's some certainty that's needed over that. One of the things that we see quite often is scholarship agreements in England. So this is the precursor to a professional contract. So they are offered to players, but with a pre-contract effectively of the professional contract. So you can't enter into the professional contract because the regulations provide that you can't enter into your professional contract until you're 17 years old. But what you can do is guarantee the scholarship, which is the provision prior to the professional contract, and guarantee that you're going to, in the future, enter into this professional contract. I mean, one of the provisions around that which would be key is the FIFA regulations in terms of the limit on a contract for a player under the age of 18, which is 3 years. So whatever you're offering in that period can't exceed, a 3-year contract in total, because technically a scholarship agreement is a professional contract under the FIFA regulations. So that's just a flavour of it, but I'm conscious that we're perhaps running out of time, and not to labour the point.
Sorry. I know that Andrea has to leave in a few minutes, so I don't know if he wants to say any words. We're gonna just keep it for more 5 to 10 minutes, I promise, Andrea. But if you want to say some words, that's the moment.
No, that's all great. I wouldn't steal any other second for this interesting conversation. So just thank you very much, and see you very soon.
Okay, just coming back to wrap it up, Sebastian, the other kind of pre-contract which doesn't violate FIFA rules is that any player that is registered with a club, when there is 6 months or less to the end of his contract, he can commit to a new club. Okay, so this is, I confess, Carol, that this is more the kind of pre-contract that I am used to deal with. So in which situations have you seen yourself as a lawyer advising a player in this, and how could this impact on the player's performance? Because usually the players are already with his head on the new club. So I know that depends on every player and every club, but usually that could impact, I don't know, the ability of the current club to have the best he can from this player in the last 6 months. How do you see that in terms of sports and legal aspects?
Well, I think in that situation, the use of a pre-contract would rather be at the benefit of the purchasing club, since it's not allowed to have a suspensive condition related to medical examination in the agreement, and that you would like then as a club to have this pre-contract and then have the I would say formal contract, which is deposited with the league upon completion of medical tests, which then will occur after the season, and hence being sure that the player is fit. Now, on our side, and you rightfully refer to the 6-month period, we will, to the extent possible, avoid as much as possible pre-contracts and have the player signed the final agreements as much as possible. What we have seen, but that is related to younger players more, is which is to me a kind of way to bypass employment law restrictions, where there is a minimum age to enter into employment agreements, and where sometimes the club tries to commit the player to an engagement that he will enter into an employment agreement, which under employment law, actually, at least in my country, is not allowed. And then you have seen again creativity, whereby, for instance, teams sign an agreement with the parents, which in French we call des clauses de porte-fort, and where the parents engage that their son, once he reaches the minimum age to sign a professional football player's agreement, that he will effectively do so. If he doesn't do so, the parents then, the parents having received some financial compensation, will be then subject to damages, to pay damages to the club that doesn't have the player. This is something we have seen, but as in general, I would say I try to avoid it as much as possible when we are within the last 6-month period of the current contract.
Patricia, I don't know from your side, but it's very common in Brazil when clubs are willing a player that is in the end of his contract, that there's if it's a good player, everybody wants to hire him. So it's a tool that in Brazil and South America is very usual to be handled, this kind of pre-contracts. Did you work a lot with this, your clients, especially if, I don't know, French
I
clubs,
agree.
they use this tool?
You have different. Of course, I agree with Sebastian. Young players, every club try to get the player or his parents linked before he leave. And we have experienced, and I have experienced a lot of English club succeeding in and convincing the parents and get a lot of young French players. And we have important clubs, and they lost their players because they trained him up to 15, 16, and then they get a scholarship, and the parents sometimes get a big amount.
Yeah.
And it's very difficult to convince the parents to stay in the club. So they try to sign a promise to contract. But I think it's very interesting as lawyer to think about this contract. And what I have seen also is it's different, not a young player. It's true that, and we have a big example in France with Mbappe. I'm not involved, so I'm free to talk about that. I think he is one of the first player who, with his lawyer, and I know her very well, they manage actually, and this is very interesting. They manage pretty well, and I have no information, so I'm free to say that. The deal was, okay, I will not extend anymore my contract, and I will leave free. And I'm sure that we will see more and more players with good agent, maybe not agent, but good lawyers. And you have to know that this player has no agent, he has only a lawyer. Being involved in his career. And from my perspective as a lawyer, from more than 30 years now involved, I do not understand why the player are not involved in their career and in the transfer contract. And what I think is they are passive. And if they are active, and if they realize that they are assets and they want to share their own assets through image rights, and I know that Sebastian has a lot to say about image rights and image contract, and being involved with incentive on their future transfer. And being involved could be also that they are not going to extend their contract and they will just go up to the end of the contract. So for me, the future is this. And I have seen some questions about, do you think that the transfer system will continue or will collapse? We will know, because we have a lot of the European Court of Justice is very interesting in the whole system. So I don't know, but I think that if the players realize and enter into the business, we will see a lot of things changing.
Well, I think, I'm sorry, Sebastian, we have to make another webinar just for you to speak about taxes and image rights. But now I wonder if we can pick some questions here, one very quickly, and then you can choose among the three of you who wants to answer. Is Elis Torso. What are your thoughts on abolishing transfer fees in football that FIFA tried to do in 2015? Maybe the most interesting from the player side, that will get more freedom and bigger salary. would it be possible and would it have any benefits? Sebastian, what do you think?
Sorry. Well,
Do you
obviously,
think
as
it's
a
feasible?
legal,
Feasible. Yeah.
yeah, as a legal practitioner, I'm actually against the principle of transfer fees. I mean, many countries have mandatory employment rules on what is the cost of termination. You work for Sony and tomorrow you work for Amazon, you leave, there is a notice period to be served or an indemnity in lieu of notice. And that's it. Now in football, it doesn't exist. We have been debating for this over years and years. I think we see various elements that tend in the entire football ecosystem that tend to evolve towards a more Northern American approach. But there is a very big difference that is there. Everything is being regulated by collective bargaining agreement, which allows you to set, in a way, competition law aside, which allows you to set certain employment rules aside, and you define a framework. And I'm speaking only for Europe. This is something that is very difficult to achieve. And so as much as I would welcome the abolishment of it, I don't know whether we are close to see it, unless, as Patricia said, the ECG at a certain point, ECJ will just impose it. And I think you will see then two tendencies. You will see high-end players who will benefit from it, who will even earn more than what they earn now. And you will have an increased need for the, between brackets, average players to be very well represented by unions, because they might be duped because of that evolution. That's a personal opinion. I'm not saying I'm right. But again, we're not inventing anything. If you see what happens in the US, you understand.
Well, actually, there's a lot of very interesting questions, and I want to, Carol, this is for you. What about Tony Sharkey? What about a sell-on if the onward transfer is between two clubs in a multi-club organization, especially if the transfer fee appears very low? Which means, we have a case here in Brazil. Brazilian club formed a player, transferred to another Brazilian player, that this bigger Brazilian player now belongs to a big holding. And it was not for free, but it was more in the line of the example of Sebastian. It was a very low transfer fee.
Mm.
How do you think the scrutiny of this will happen or should happen?
So, well, one, I think that it's about that constantly evolving drafting piece and the lawyers being on top of these issues, and that's why you need to be across the industry developments. So when drafting those sorts of provisions, especially with clubs that are involved in kind of the MCO model, that you're factoring in some provisions for fair market valuations. So they're the sorts of things that the Premier League has introduced, particularly with regard to transactions that aren't at arm's length. And so it's effectively that sort of thing, that you want to have an independent valuation if it's not an arm's length transfer. If you don't have a provision in the contract for that, then you're going to have to sort of effectively rely on implied terms of duties of good faith, that ultimately you're saying, because it's a transfer within a multi-club ownership structure, it's not at fair market value, and therefore implicitly, you've been duped. So it would be a more difficult argument to run. The better provision would be to factor it into your drafting in your contract.
Yeah, the value of a player, of its registration, is not a commodity, so it's not easy to put a market price on it. I have another question here from Namit, dear friend of mine, and I wonder if he could answer to me, because he's asking, listen, how do you calculate the percentage of sell-on fee when, or the amount of equivalent to the percentage, when there are a group of players sold together? And about this, currently we have a case where Internacional transferred Yuri Alberto to Zenit from Russia. Then Zenit released him on a loan to Corinthians from Brazil. And afterwards, Corinthians bought the player. So in this middle of these two transactions between Corinthians and Zenit, there are loan of players, trading of players, granting of buying options in favor of Zenit, and sell-on fees again. So don't tell me about it, Nami. Let's see how it's going to happen. Just one thing about trading of players in calculating the sell-on fees. I think that everybody should take into account that you have more reliable or levels of reliable sources to calculate that. And in my humble point of view, since CES represents the University of Neuchâtel jointly working with FIFA somehow, maybe this is a good, reliable source to rely upon when you are trying to calculate or to make a evaluation of a player. Another one, then this is for you, Patricia.
Just before you pick up the question, Daniel,
Yes.
I think we have also to mention the options. Option to buy, option to sell, and option in the contract. And I've seen a lot of contract and sometimes option with a fee. So I give you an option to buy my player, and to get this option, you have to pay me such an amount, and this amount could be discounted on the from the transfer fee if the transfer occurs. And these option contracts are not pre-contract; they are option and very interesting to deal with, very interesting to draft, because it gives the club the possibility to deal with different possibility. You could give an option on one player, but I have seen option of several players. And option given to a club, from an academy or a small club to a club. And I agree that multi-ownership and organization are the new, probably what we've gonna see. And maybe I know that FIFA want to regulate, UEFA want to regulate this, but this is the new, these options are a tool to guarantee that these players, mainly young players, are to be transferred or loaned under the option to another club. And of course, and I repeat, I think that there is two ways. Or the transfer system will collapse. Maybe. Yeah. I thought he would collapse in 2001, but he didn't. Or players will be much more involved, even in the option, because the option between the two clubs is always, as I can see, always depending upon the agreement of the player. Maybe we will see the next step is the player being involved in the option and sharing also the fee and negotiating an incentive on the option, on his agreement. So that for me is the future.
Yeah,
players involved.
One thing that is exactly one of the questions that we received from Juan Manuel Lopez Ruiz. He says that a Spanish club and a Mexican club, the player was transferred to a Mexican club, and the player already, and there was a sell-on fee in favor of the Spanish club, as far as I understood. Okay, if I'm changing the countries, don't blame me. And in this transfer agreement, the player has already accepted, and there was a clause literally saying that he accepted to be transferred to another country, which is very broad, right? And now the player are not accepting to go to this other country. I have my position. I know it's the same as Sebastian, but I think it's exactly what I think I can answer, and you can disagree if you want. Of course, the player, when he says that he accepts to go abroad, it doesn't mean that he accepts to go to anywhere abroad, right? To accept to go to a club, you should know exactly which club it is and what are the conditions in this particular club at the moment of the transfer. Am I right?
Fully agree. Well, actually, to me, it's just the basics of contract law. Have you agreed on the object of a transaction? Yeah. What have you agreed upon?
Basically, what I would interpret this like saying, okay, I don't have anything against going abroad. This is something that, but it doesn't mean that he accepted to go to any club in I don't know where. So the last one, and then I think we're going to have to wrap it up because we don't have more time. Maybe Carol can bring some extra layer of protections to the selling clubs because of FA usually at least shows to be more organized by taking care of the financial duties of the English clubs. It's not very lenient to the duties of the English clubs, if I may say. And we salute that. We salute that, Carol. But the question is, who monitors whether the bonus conditions have been met? Is it the onus on the selling club to check, or is the buying club obliged to tell them when the player has met the targets?
It depends on the wording of the contract. Normally, there will be some provisions that might not be easily, available to the former club. But ordinarily, the statistics are fairly easily available, and so you would imagine that the club that is due the money will analyze its data and submit the invoice, and if there's any dispute over that, then ultimately, the current club will have the accurate information. But yeah, normally you provide for it in the contract.
But again, depends on the wording of the contracts. You can impose also fines by the lack of information.
Yeah.
And there are some in jurisprudence, of course, very interesting about the duty of information of the buying club. Because since the buying club is the only one that is going to see that these targets were achieved, there is an extra based on bona fide and everything, a good faith, that you are the only one that can. When you promise to pay, you knew that you would be in a position that you could see everything, and your partner that you promised to pay was not in that position anymore. So to get the player, you promised to comply with this duty of information, and then all of a sudden, so this was a very interesting jurisprudence from the CAS, more than one, about strengthening the duty of information, even if the contract is silent about it or is shy in describing this duty. So I'm not happy to end this because I always learn a lot with you guys, all of you. And I'd like to really thank you. Although this initiative belongs to all of you and all the IF members, without which it would not be possible to make these webinars on this level, to make the master degree on football. And it was really a pleasure and an honor to host you this time. Final remarks in 15 seconds, every one of you, and each of you. Please, Carol.
I think we've said it's a constantly evolving landscape, and as lawyers, you just really need to be on the development so that then you're future-proofing the contracts. So no pressure.
Patricia.
I'm very happy to be part of this discussion. It's a no-end discussion. And that's why is for me really a fascinating topic, transfer and all different kind of contract that are linked to this business. And I think we have to, as a lawyer, we are lucky because it's alive, always alive. Every month there is something new, a new jurisprudence, and new questions and new regulations. So hopefully we have a lot of work, and I'm sure that all the students and the young lawyers who wants to be involved in the football and all legal issue, we have to and Sebastian know that we, depending on our country, we have so many different framework, different law, and on the top we have the FIFA regulation. But dealing with all this different culture, different legal culture, different business, there is place for everyone. So welcome in the business, football business and football law.
Thank you, Patricia. Sebastian.
Couldn't say it any better. Some people say that lawyers are the problems of everything in the world, but it definitely looks like there's a lot of work for us. So to all students, hang in there, follow the master, train yourself, and good luck. There's work for everyone. Bye-bye.
Well, before I finish this, I just want to, with the permission of Carol and Sebastian, say that I met Patricia for the first time in my life, representing an investor that has 10% of the economic rights related to Ronaldinho Gaúcho. And Patricia was representing PSG, and I was seated inside FIFA headquarters with an injunction granted by a judge from my town, obliging Grêmio to make me to be inside that courtroom. That is just to mention that you cannot work in football only with FIFA rules, with doping rules. You also have to keep in mind which tools do you have according to the place where you are seated, in Porto Alegre, in Manchester, in Brussels, in Paris. So you have to look at all of this. That's why I think it's one of the most rich areas to work with law applied to such a beautiful sport. And I may say that we are here now in this initiative of ET with IAF because Patricia had the idea, the effort, and I don't know what kind of light she had to create IAF. So we all owe you a lot about this development of sports law. That being said, I'd like to thank you, all the survivors that are until now with us and the one that has left also. We took a lot of your time. I hope you could enjoy our discussion. Thank you very much to all.
Thank you, Daniel. Thank you all. Thank you. Bye-bye.
Bye-bye.